Welcome to the channel Scientellectual. Now we are in the chapter 23, Miscellaneous. The sections that we are covering in this video are section 142 to section 146. The relevant rule that will be discussed is rule 131 and form 27. Section 142 deals with fees. Subsection 1 says, fee as prescribed by the central government is to be paid in respect of grant of patent and application therefore, and also in case of other matters related to the grant of patent. Subsection 2. The controller shall not do any action until fee is paid, wherever fee needs to be paid. Some actions are free, some actions are payable. Whichever is payable, that action will be done only if fee is paid. Subsection 3. Where a fee is payable in respect of filing a document at the patent office, it is to be paid along with the document or within the prescribed time. Prescribed time means there is time limit specified in relevant rules within which the fee needs to be paid. Document shall be deemed to be filed, that is, it will be considered that it is filed only if fee is paid. It will not be deemed to be filed if the fee is not paid. That is, once one pay the fee, then only the documents will be considered that it is filed or else not. Subsection 4. Where a principal patent is granted later than 2 years from the date of filing of the application, that is, date of filing of the application is some date and then 2 years has passed, then the patent is granted. The fee which have become due in this meantime, it will be paid within a term of 3 months from the date of recording of the patent in the register. There is a date on which the patent is getting registered. From that date, the person will get 3 months time to clear the due fee, or within extended period not later than 9 months from the date of recording. That is 3 to 6 months. Maximum 6 months more can be given. After 9 months, it is not possible. So, within 3 months from the date of recording of the patent in the register, the person will clear the due, or he can get an extension of time up to 6 months, not later than 9 months. Section 143. Restrictions upon publication of specification. An application for a patent and any specification which has been filed with respect to the patent application, it shall not be published by the controller before the expiration of the period as prescribed under section 11A subsection 1, or before the same is open to public inspection as said under section 11A subsection 3 or section 43. In this regard, we can mention what is that time period. Section 11A subsection 1, where it has been said that publication will be done after 18 months from the date of filing. So before 18 months, no application will be published. As per section 11A subsection 3, publication will be done if there is no secrecy direction, or the application is not abandoned, or the application is not withdrawn. So if these cases happens, then application will be published. That is, no secrecy direction, it is not abandoned, and it is not withdrawn. Under section 43, it has been said that on the grant of patent, the controller shall publish the fact that patent has been granted. Then the application, specification and other documents will be open for public inspection. So these criteria will be fulfilled, or else the application or specification will not be published by the controller. Section 144. Reports of examiners to be confidential. The reports of examiners sent to the controller will not be open for public or open to public inspection, or it will not be published by the controller. It will be very confidential. And such report shall not be liable to produce or inspect in any legal proceedings as well, unless court certifies that for any justice it is required to produce or to inspect. Then only those can be published, or else the report of examiners to the controller will be always kept confidential. It will neither be inspected nor be published. Section 145. Publication of official journal. The controller shall publish periodically an official journal which will contain the informations as required to be published. Every Friday, the controller publishes the official patent journal electronically, which is available on the Patent Office website. Section 146. Power of controller to call for information from patentees. This section is very important. Subsection 1. The controller may at any time during the continuation of patent by notice in writing require a patentee or a licensee, whether exclusive or not, to furnish information or periodical statement to what extent the patented invention has been commercially worked in India. Within 2 months from the date of such notice, the person, that is the patentee or licensee, needs to furnish the information regarding how much or to what extent his patented invention has been commercially worked in India. Subsection 2. Every patentee or every licensee shall furnish in such manner and form and such interval as may be prescribed, that will be discussed just later on, to the extent to which the patented invention has been worked on a commercial scale in India. So there is a time period during which the patentee or licensee needs to furnish how much or to what extent his patented invention has been worked in India on commercial scale, and there is a form through which he will furnish all the information. Subsection 3. The controller shall publish the information as mentioned under subsection 1 or 2. Here comes the relevant rule which says how and when the patentee or licensee will furnish the information to what extent his patented invention has been worked in India on commercial scale. The rule is Rule 131 and the form is Form 27, through which the patentee or licensee will furnish the information. And the time period is, it will be submitted in respect of every financial year. Financial year is, it starts from 1st April of any year and ends to 31st March next year. Now, dated 20th October 2020, there was a notification by central government. This statement of working has been amended. And earlier it was like that the statement of working had to be furnished in every calendar year or with respect to calendar year. Now it has been changed or amended to financial year. The relevant portion of the Gazette notification is the statements referred to in Sub-Rule 1 shall be furnished once in respect of every financial year, starting from the financial year commencing immediately after the financial year in which the patent was granted, and shall be furnished within 6 months from the expiry of each such financial year. That is a very important amendment has done in recent time. Related to Form 27, which is related to statement of commercial working or to what extent the patentee or licensee has worked commercially in India. There is no fee for Form 27 submission. Earlier in Form 27, patentee or licensee needs to furnish all the particulars and details regarding the extent of his patented invention working commercially in India. Now, an approximate value can be given. This amendment has also been done in that Form 27. Thank you all the viewers for watching the video. Hope you like it. Please give a like and please share and subscribe the channel Scientellectual. We are providing the necessary informations regarding Indian Patents Act 1970. Hope this will be helpful during the preparation of Indian Patent Agent exam. Thank you all.